This is a lecture from Open Tuition. For the free lecture notes that go with this podcast, please visit opentuition.com.
Page 69, the Memorandum and the Constitution. The Constitution, remember, is just the articles. The Memorandum, historically, it was a very, very important document. I mean, there were 7 clauses within a memorandum. There used to have to be 7 specified clauses within a specified sequence. And one of those clauses, it used to take me half a day just to talk about one of those particular clauses. Now, it's just a matter of record, just a historical document. It just says, we, the undersigned, wish to form a company. We agree to become members. We agree to take at least 1 share each. And that's all it does. It's just a formal confirmation of the wishes of the original shareholders to create a company. That's all. So the importance of the Constitution, the importance of the Memorandum has now disappeared with effect from the passing of the 2006 Companies Act. The Constitution, I've already said this at least twice, it's the articles, the resolutions which affect the articles, and any agreements which affect the articles. And the articles, whereas they were secondary, whereas the Memorandum was the major document, the articles were the secondary document, that role has now changed. The Memorandum is almost of nil consequence, and it's the articles which are the prime document. And when we talk about articles, page 70, when we're talking about articles, there are 2 particular questions that your examiner can ask. Articles affect everything. Articles are the internal regulations. The articles set out the rules of the company. And when you become a shareholder in my company, when you buy shares in my company, either from the company or on the open market, you are entering into a contract. The terms of the contract are what is written in the articles. So you know before you buy the shares, or it is available for you to find out before you buy the shares, what the articles say. And if you don't like what the articles say, then don't buy my shares. Just stay away. I don't want you. But as soon as you buy those shares, you then enter into a contract with me, the company. But at the same time, you're also entering into a contract with all the other shareholders, individually. So Sandra's in contract with me, the company, but she's also in contract with Eddie, who also happens to be in contract with me, the company, and he's in contract with Sandra, who's also in contract with Jan. And so it is that we have these multiple contracts. Each individual one of you is in contract with each other individual one of you. And you're in contract with me, the company. And it's the articles which set out the terms of that contract. These are the rules under which or by which the company will operate. So when a person becomes a member of a company, it is as though they have separately entered a contract with the company and with all the other members individually. The terms are contained within the articles, and the effect is to bind the members to the company. These are the rules, and we can't break those rules. We can't enter into activities which are against those rules. And we've got the first case here, Hickman and Kent or Romney Marshall. We're back with sheep again. The Sheep Breeders Association. But of course this is also on your Superman list because of Kent. Hickman is the chair of this Sheep Breeders Association. I think I need to explain what a Sheep Breeders Association is, because from what I understand from this part of the world, you don't have such extreme ideals as we tend to have in the UK, with reference to sheep and breeds of animals. Well, you do in terms of domestic dogs and cats. I understand that you're very keen on pedigree dogs and cats, which are of purebred history and parentage. But we also extend this into other animals, pigs and sheep and hens, chickens. We have different types of chicken, and they've got to be purebred, and the cockerel of these rare breeds has got to mate with the hen of these rare breeds. Pigs, the Leicestershire saddleback pig is a pig which has got black skin going round its middle, and it looks like a saddle that you would put on a horse. And there are some very, very keen and enthusiastic people who are lovers of the Leicestershire saddleback pig. And the Hickman, the Kent or Romney Marsh sheep, is another particular rare breed of sheep. And it's different from other types of sheep. It's different from the Wensleydale sheep and from the Texel sheep. These are all these different breeds of sheep. A sheep is a sheep, isn't it? That's what a sheep is. But no, not in the UK. We have different types of sheep, and sheep lovers know and can see. They can look at a sheep and say, that's a Wensleydale, that one's a Texel. Anyway, this Kent or Romney Marsh have got these own particular characteristics. They've got cute little ears, and the right one just bent over a little bit, and they've got a little curly tail, and their coat grows in a different way and changes colour halfway through April, and then it's I'm making it up, but this is the sort of thing, the detail, and the distance between the eyes should be exactly 15 centimetres, a little cute little nose. And so this is what a Kent or Romney Marsh sheep looks like. And it's said in the constitution of this association, it's not a company, it says in the constitution of the association that if there is a dispute as to whether a flock of sheep are genuine Kent or Romney Marsh and therefore registerable, if there's a dispute, then the two disputing people, the sheep owner and the association, will go to arbitration. And they'll ask an independent expert, and the independent expert will look and say, the little ear doesn't bend over far enough, or whatever. Pigeons. We have that. I used to live next door to a man who drove his Rolls Royce, his wife with a soft-top Mercedes, and heated outdoor swimming pool. And he was a pigeon man. He liked pigeons, purebred pigeons. And you don't have this here, do you? What they do at a weekend is they put their pigeons, some of their pigeons, they put them in a basket, and all the other pigeon lovers around the area in their association will put the baskets into a lorry, and the lorry will drive to the south of England, or sometimes to the south of France, and then with a mechanism within the lorry, all the pigeons are let out at the same time, miles away from home. And the pigeons fly home. And they race them. They're called racing pigeons. And these pigeons are going batting away on, trying to get back to their home. And the first one back wins. And they can win substantial amounts of money. This is amazing. So we have people who specialize in probably areas that you here don't tend to specialize in. You don't have pigeon racing, do you? I don't think you have pigeon racing. You don't even have people racing, do you? No pigeon racing here, but we do have them in the UK. Anyway, these two disputing parties will submit themselves to arbitration in the event of a dispute as to whether a particular sheep or flock of sheep are genuine Kent or Romney. And Hickman was registering his flock. He's the chair of the association. And he was registering his flock in this particular year. And the association looked at his sheep and said, no, we don't think they are. We think that you've got impurities within your flock of sheep. And so he argued and said, these are I know what a Kent or Romney Marsh sheep looks like, and mine are. So he sued and took the association to court. And the court said, what are you doing here? And he said, they won't register my sheep as Kent or Romney. And the court said, no, what are you doing here? Why are you in court? It says within the Constitution that if you have a dispute, you'll go to arbitration. So Hickman said, well, I thought the court was more important. And the court said, we are more important, but that's irrelevant. It says within the Constitution that if you have a dispute, you will go to an independent expert. You won't go to court. And so they had to go to the independent arbitrator rather than go to court. That's the rules. The rules say, in the event of a dispute, this is what we'll do. And you have to follow those rules. So it binds the members to the company. The third bullet point says it binds the members to the company. But also the fifth bullet point, it binds the company to the members. Not only must the members obey the rules, but the company must also obey the rules. So how the company treats its members must be according to the rules. In the case Pender and Lushington, we're in a private company here, and the chair of this private company is a man called Lushington. This man here, the defendant. He's the chair of the company. He's the big chief of the company. And it's a private company, and it says that if a member is to be able to vote at a general meeting, then he must have been a member for greater than 3 months. He must have been a member for more than 3 months, registered on the register of members. It said also you had 1 vote for every 10 shares, with a maximum of 10 votes. That's clear enough. If you have 10 shares, then you get 1 vote. If you've got 30 shares, you get 3 votes, so long as you've been a member for more than 3 months. We have one particular shareholder who had 167 shares. So his maximum. He has a maximum of 10 votes, so he will use the voting rights attached to 100 of those 167. But he's then disenfranchised with reference to the other 67. He has no voting power there. So what he did was he transferred 67 of these shares to Pender. And he did this in January. He now has 100 shares, he has 10 votes, maximum voting power. But Pender also has 6 votes. So it means that our big shareholder is now fully utilizing his 167 share voting power, so long as Pender votes the same way that he is directed to. It doesn't matter that Pender has no brain. That doesn't matter. Pender is a registered shareholder and was a registered shareholder in January. The meeting in May. There's a big contentious resolution. Lushington and his friends wanted to vote one way, but some shareholders, including our big one, wanted to vote against the chairman. So there's a big discussion, a big debate in the general meeting, and Lushington, the chair, said, right, it's time to finish the discussion, let's have a vote. All those in favour, and Lushington and some others put their hands up, and they had 832 votes. And then he said, all those against, and our big shareholder and Pender put their hands up, and the vote against was 835. So the resolution, and Lushington had lost their resolution. And Lushington looked around at these 835 voters and saw Pender and said, I'm not counting your votes. Your votes don't count because you're just a puppet of this 167 shareholder. You're just a mere puppet, and it's not right. You're not a proper shareholder. You're not a genuine shareholder. So he discounted these 6 shares, these 6 votes, took the 6 votes off, said 829, therefore me and my friends have won the vote. And Pender took the chairman to court and said, you're breaking my contract. I am in contract with you. I've done everything right. I have 67 shares. My name is on the register of members. It has been there for more than 3 months. I therefore have 6 votes. And the court agreed that Lushington and the company, therefore, was breaking this article's contract. Well, it's not lifting the veil so much, really, is it? It's just saying the articles are a contract. They're a contract between each of you individually with each other individually. So you are bound to each other, but they're also a contract between you and me, the company. So not only must you obey the rules according to the company, Hickman and Kent or Romney, but also I'm in contract with you, and therefore I must obey the rules. The third one is Clark and Dunraven, and that's also on your Superman list, because of Clark Kent, of course. And this is what says, this particular bit, or this case, illustrates that members are bound to each other. This is a case about a sailing regatta at the Mudhook Yacht Club, the Easter Regatta. And it's a little bit awkward and complicated, and it's in an area which you're not going to be particularly interested in. But basically there are sailing rules. And when you sail, you have to obey the overall rules, the right of way. Two boats are going on a collision course. One of them has to be in the right and the other therefore in the wrong. And the rules are quite clear. And you know, everyone who sails will know the rule about the boat on starboard has the right of way over the boat on port. So we accept that. But there are, in addition, the Royal Yachting Association has its own rules as well. And it says, for instance, that if I sink your boat, then I should pay you compensation at a specified rate. The Mudhook Yacht Club, in their Easter Regatta, had said if one boat damages another, if one boat sinks another, then they shall pay compensation at a different specified rate, greater than the Royal Yachting Association rate. And Dunraven sank Clark's boat. So Clark sues him and says, I want my compensation according to the Mudhook rate. And Dunraven says, no, I'm only going to pay you according to the Royal Yachting Association rate. So he went to court. And the Mudhook Regatta rules, therefore the Constitution, were the rules that we should be sailing under. And therefore Clark won. No matter that the Royal Yachting Association, with its prefix of Royal, no matter the Royal Yachting Association said a lower rate, the Constitution of the regatta said this is the rate that shall be paid, and therefore members within the association are required to obey those rules. But the articles don't create a contract between the company and third parties. Ely and the Positive Government Life Assurance Company, Ely and Positive Government Life Assurance, was about a solicitor who had been asked to form a company, and as part of the remuneration that they were going to pay, he was a shareholder also, and he was also appointed by the Constitution to be the solicitor of the company for life, or until he chose not to be the solicitor of the company. So he was appointed to the position of the company's solicitor, and it was a protected position. He was going to continue to be the company's solicitor for as long as he wanted. After about 10 years of company life, the other directors said to Ely, we don't want you as our company's solicitor anymore. You're sacked, you're fired as the company's solicitor. And he said, you can't do that. It says within the Constitution that I shall be solicitor for life. And so it went to court. And the court asked Ely, so why are you here? On what grounds? What justifies your appearance here? He said, they're trying to get rid of me as a solicitor, and my appointment is through the articles, and I'm a shareholder, and the articles bind the company and the shareholders in contract. And the court said, the binding force of those articles is limited to the company and the members in their capacity as members, and not in any other capacity. So the company will treat you properly as a shareholder, as a member, but they don't have to treat you properly as a solicitor. The contract is between the company and the members in their capacity as members. There is a little Latin expression which is applicable here. The articles bind the members and the company inter se qua members. It binds them amongst themselves in their capacity as. It binds them inter se qua members. Inter means amongst, se themselves, qua in their capacity as members. So Ely lost his case. He did not have a binding contract according to the articles. If he had separately negotiated a contract with the company not in the articles, then he would have been protected and the company would have been in breach. But he didn't have a separate contract, and the binding force of the contract within the articles only extends to the other people in their capacity as members, and not in any other capacity. This applies also to directors. A director who is appointed by the articles doesn't have a contract. Doesn't have a contract that he can rely on. There's a case called Beattie and Beattie. That should be in your plaintiff defendants' same names. Beattie and Beattie was a family company getting rid of one of their family directors. And he said, no, I've been appointed by the articles. It went to court, and the court established and confirmed that the articles do not form a valid binding contract between the company and somebody who is a member but who is claiming in a different capacity. That clear? You happy? Okay, I said there are two areas in which your examiner typically will ask about articles. The first one is about the binding force. The second area that he will commonly ask is about the alterability of the articles. The alterability. And there's a basic fundamental rule that you can change the Constitution.